Hello guys, welcome to my lecture. Today we will be talking about the two cases that I spoke about in my last video. The first being Virgin Technologies versus Mohammed, and the second being Odutola Holdings versus Ladejobi. Now, in this video, I will be talking about Virgin Tech versus Mohammed, but in my next video, I'll be talking about Odutola Holdings versus Ladejobi. Now, the essence for these cases, the both of them, is to discuss every single thing that we've learned for the past 8 lectures. That is, this video being the 9th lecture. I want you to see how the court has been able to discuss about these things that we spoke about. We are going to read the facts together. We are going to see the issues that were raised in the High Court, in the Court of Appeal, who are the Supreme Court. Do you understand? And we are also going to see how the justices interpreted the relevant section of CAMA while trying to bring a solution to the issues that have been raised. So it is going to be a really fun ride. Just make sure that you understand as I teach, and make sure that you have watched each of those videos very well, the 8 videos before this one, and you totally understand it. Then you'll be able to understand what exactly I will be teaching in this lecture. And now the fact of the case, Virgin Tech versus Mohammed, will be showing on your screen, and I'll be reading through the fact for proper understanding. Now, the fact in the case of Virgin Tech versus Mohammed is that the plaintiff appellant, who was the CEO of the appellant company, discovered that the defendant respondent, who was a director and a co-signatory of the appellant's account, withdrew money from the account and transferred it to a personal account without authority of the company or knowledge of the CEO. The company thus instituted action seeking interim injunction to restrain the respondent from further dealing with the money which was in the respondent's account in the respondent's bank. The respondent raised preliminary objection challenging the locus of the CEO to institute action in the name of the appellant company. At the trial court, the High Court upheld such preliminary objection, and therefore there was an appeal. Now, at this point of the note, I want you to understand that the essence for the appeal basically is because, according to the fact, you would see that the respondent raised an objection challenging the locus of the CEO to institute action in the name of the appellant, saying that it is not within the power of the CEO to institute actions. Do you understand what that means? It means that it should be either in the board or in the general meeting, but definitely not in the office of the CEO. The CEO here being the managing director that I spoke about in section 88B, section 89(1), and section 91, to have been raised to a third organ. Probably the counsel in this case did not know about these 3 sections that I already quoted. When we now go to the issues before the Court of Appeal, the first issue on appeal was whether the MD of the appellant company can authorize institution of court proceedings in company's name. And then the second issue was whether the court erred, that's the trial court, erred in holding that the suit was incompetent for want of requisite authority. So basically, the second issue is saying that the CEO has not gotten the right authority to have instituted such proceeding. Can we say that the trial court erred when it said that the CEO was in fact incompetent to have brought a suit to court without the requisite authority? Now, the court held in this case that in section 87 sub 1, 2, and 3, it confers general powers on the directors to conduct business. Note that I'm talking about the new CAMA. I want us to get accustomed to the new CAMA instead of the old CAMA. but this particular case was decided on the old CAMA. That is the reason you see section 63.123 of the old CAMA, but which is now equivalent to 87.123 of the new CAMA. Now, to proceed, the court held that, however, the power of management and control of company, insofar as they affect instituting legal action in company's name, is vested in members of general meeting in accordance with section 87B. However, this is only when the board of directors refuse or neglect to do so. In explaining this particular part, do not forget that I said in a former video that part of the exceptions that the board of directors are the ones that can, manage the company's business would be what we would find in section 87 sub 5. So in this case, the court is saying that the power is vested in members in general meeting. However, that is where the board has neglected to do so. Now, to continue, by virtue of section 87 and 89, principal officers are enabled to take steps against activities done by others which may be inimical. I explained that inimical means tending to obstruct or cause harm to the company, which is what the CEO did. Thus, the CEO's authority to act on the company's behalf is implied, as held in the case of Shoti Minu versus Ocean Steamship, where the court held that in urgent cases, an officer of the company may act to institute action to protect the company's assets, in which situation the company can ratify the act and adopt proceeding, or reject the act and rescind proceeding. To explain what this is saying, they are saying that the company cannot all the time wait for there to be a board resolution, because there might be certain times where something can be so urgent, as Shoti Minu versus Ocean Steamship has said. Certain issues can be so urgent that the company cannot just be waiting all the time to say, okay, let us wait for this, let us wait for resolution. No, there are certain officers in the company that should have the power to be able to take certain steps and certain actions that will bind the company. Then the company can, moving forward, that's later on, either ratify the act and adopt proceeding, or reject the act and rescind proceeding. Now, I need you to understand that this is the court's interpretation of section 87.123 in line with section 87 and 89. Now, the court went further to say that also in the case of Ashton Nigeria Limited versus African Continental Bank, the Supreme Court held that the CEO's authority to act is ordinarily presumed until the contrary is established by the party who asserts otherwise. In this case, no contrary has been established, which means that when a proceeding is to be instituted in court by the CEO, the court can ordinarily presume that the CEO has such authority. The only time such presumption will be rebutted is when the other party, in this case, decides to bring either the articles that expressly prohibits the CEO from doing such act, or a resolution from the board meeting expressly prohibiting the CEO from as well doing such act. But where there has been no resolution, where there has been no articles that say that the CEO cannot act, then the CEO's authority to institute actions are presumed. Now, also, in the case of Ladejobi versus Odutola Holdings, which I will still discuss extensively in my next video, it was further held that it was advisable for the CEO to take steps against the respondent in such urgent situations where the alleged conduct was inimical to the company. Now, by virtue of section 87 and 89, the CEO's suit was not void ab initio, since the company could ratify and rescind the same. Void ab initio means void from the very onset. So the perspective of the Supreme Court in this case was that no, we can't say that the CEO does not have authority. What we are saying is that until the contrary is proven, he should have authority. Until there has been a resolution brought before the court that the CEO doesn't have authority to institute this action, he should have the authority. Until there has been the article brought into evidence to show that specific parts of the article has taken away the power of the CEO to institute action, then he should have the authority. Therefore, the Court of Appeal continued and said that the consent of the company isn't a condition precedent for instituting suits in its name under section 341. What the CEO did was to adopt the irregular procedure in an emergency. The Court of Appeal allowed the appeal and set aside the High Court's judgment. However, from this judgment so far, there are certain things that I would like us to note. Now, I want us to note that there are two flaws in this Court of Appeal's judgment. The first one is that the Court of Appeal stated that the CEO's authority to institute actions on company's behalf is implied. However, Section 89, that is a statutory authority, has given this authority to the MD to act on behalf of the company. It is clearly written in Section 89 that the CEO can act on behalf of the company. Therefore, the CEO's authority cannot be said to be implied, as it has been expressly backed up by the statutes. The second is that the court also stated that the power of the managing director to institute actions on company's behalf was subject to subsequent ratification by the company. However, when we read the provisions of Section 88, it says any act of the members in general meeting, board of directors, or the managing director we bind the company as long as it is done in the usual way of carrying on business on behalf of the company. Now, this means that there need not be ratification since the managing director has been taken to such a level. He is now an organ. Therefore, his acts are then known as the act of the company. How then can we say that his act is still subject to ratification? It is not possible. So it is on these two grounds that I am saying that the question of ratification should not come up, as well as the question of implied authority of the CEO. So I hope you all have understood the case of Virgin Tech versus Mohammed, because it basically analyzes almost everything that I've said so far, especially in relation to the managing director and the powers of the managing director. But I want you to hold something. When the court was talking about the power of the managing director to act, the court kept on talking about Section 87 and the business of the company. I am going to have a lecture where I will discuss the business of the company separately, but I want you to hold that before we go into our next case, which is the case of Odutola Holdings versus Lade Jobi. See you in next class.